A very good evening, everybody. I'm assuming that more people are going to join in soon, and since it is time, I'm assuming that I should start the session now. But I will give the participants a brief recap of what has happened the last time, because there has been a gap of about 4 days before the vacation. We were discussing, the last session was about procedural law and substantive law. We had tried to understand the definition of what substantive law is and what procedural law is, and how these two laws are interconnected, and that the substantive law can exist independently of the procedural law, and how the procedural law cannot exist independently of the substantive law. And the substantive law is what defines what a right is and how a violation takes place of the right, and the remedy for such violation, and the essential ingredients of a violation, and the classification of such violations, while procedural law is a mechanism to implement the substantive law. And we were also discussing in the last session about bail, and what bail is, and what are bailable offences and what are non-bailable offences. We were discussing that the schedule in BNS lists out offences that are bailable and lists out that offences that are non-bailable. Usually in bailable offences, the accused can ask for bail as a matter of right, and in non-bailable offences it is up to the discretion of the honorable court whether or not to grant bail to the accused. There is different kinds of bail: default bail, anticipatory bail, etc. and etc. We had discussed all of this in the last session. And one other thing that we were discussing in the last session is the difference between cognizable and non-cognizable offense. Cognizance is to take notice. An offense is an offense against the society, and if the society is to take notice of the offense, it is a grave offense, and it comes under the cognizable offense category. And in a cognizable offense, the investigating officer or the investigative agency has got the power to detain the accused or the subject without the explicit permission of the honorable court, without a warrant. But then in non-cognizable offences, which are also listed in the schedule in BNS, but during the non-cognizable during the investigative stage of the non-cognizable offense, the investigative agency has to procure explicit consent from the magistrate in the form of a warrant to detain an accused. Now we will move on to the next chapter, which is summons and warrants. This is from chapter 6 of BNSS, Bharatiya Nagarik Suraksha Samhita, the act that has replaced CRPC. The sections and the schedules, the numbers differ, but the processes and the methodology does not differ. And I shall share the PPT that I am going to be using now with the participants after the session is done. So probably by tomorrow the participants will have access to the PPT that I am using. Now coming to what are summons and warrants. Usually during court proceedings, there is a need for certain people to be present there so that they may be questioned. There is a need for certain objects to be presented in front of the honorable court so that they may be examined in the form of evidence or otherwise, in the form of witnesses or accused or otherwise. There is a lot of need for people who are connected in some form with the case at hand that has come for trial. Now, the mechanism or the process that can compel the appearance of either an accused or a witness or certain things or objects, these processes are called summons and warrants. Now, there is two names, summons and warrants, for a reason, because summons are served, warrants are issued. We will come back to the meaning of the word service and issuance. Usually, summons are associated with offenses that are not that grave in nature. Summons are usually associated with the person who is getting served the summons. But warrants, on the other hand, are in the form of directives issued by a higher authority to a lower authority, in this case by the honorable court to the investigative agency, that is usually the police. Therefore, warrants are issued and summons are served. Summons are served to the person who is supposed to be summoned, and summons are usually associated, and the gravity of the offense that is associated with summons is less, and the gravity of the offense that is associated with warrants is more. Now, there is a specific process that is supposed to be followed with respect to the service of summons. The summons, the origin of the summons is the court, obviously, and the persons that get served the summons are either accused or witnesses. Any witness, there is kinds of witnesses, we will get into this in more detail at a later stage, but right now we will only limit the discussion about witnesses to types of witnesses. Not all types are being discussed here, but usually the types of witnesses are prosecution witnesses, the witnesses introduced by the prosecution, the lead examination is done by the prosecution, and the cross is done by the defense, and the re-examination is again done by the prosecution. Now then come the defense witnesses, the witnesses that are introduced to the court by the defense attorney. The lead examination is done by the defense, the cross is done by the prosecution. Then the court witnesses, on the off chance that the court is privy to the information about a person who can be called as witness, usually the expert witnesses and some certain other types of people who are usually involved in the trial are summoned to the court. And they are called the court witnesses. We will get into the integrity of the court witnesses at a later point of time. Now, when the summons are served, the summon is said to be served if there is a process that is involved, and if that process is followed to the T, and only when that process is followed to the T is the summon said to be served. Now, how is the summon served? Number one, it is supposed to be in writing. There is no such thing as oral summons. The summons are said to be put in writing, and there is supposed to be a seal of the court, and it is supposed to be signed by the presiding officer of the court. Electronic signatures also are allowed to be put there, but the summon is supposed to be in writing, and it is supposed to be signed by the presiding officer of the court, and it should bear the seal of the court of origin, and a duplicate is also supposed to be issued. This duplicate doubles up as a receipt. This duplicate is supposed to be signed by whoever it is that is said to receive or said to have summons served upon him. It is the duplicate that is supposed to be endorsed by either the person or the company or any recipient of these summons. How are these summons supposed to be served? These summons are supposed to be served by a police officer. Usually it is the police who is given the responsibility of service of summons, but not just the police are involved in serving the summons. The officer of the court that has issued the summons is also sometimes in charge or given the responsibility of serving the summons. Any other public servant for that matter can also be given the responsibility of serving the summons. And there is a register that is supposed to be maintained in the court and also at the police station, containing the addresses, the emails and other details, the phone numbers and other details of the people that have had summons served to them. Now, how are these summons supposed to be served? Usually it is preferably the summons are supposed to be served personally. The police person or any other person that we have discussed is supposed to go to the person on whom the summons is supposed to be served, and is supposed to do it on a personal basis, and the duplicate is supposed to be endorsed by the person on whom the summons is served. That doubles up as a receipt, as I was telling. Now, not all the time the summons get served to people. Usually in legal parlance, we will once again get into this in more detail during the later sessions, but in legal parlance, a company is also a legal person. A company is having the liability and the responsibility of a person, legally speaking. Therefore, a summons can also be served upon a legal person, that is a corporate firm, a company or a society or a trust. Now, who gets, since it is not an actual person, who does the summons get served to? Either the director, the person in charge usually of a company, a person who is given the responsibility by consensus in that company, say the director, the managing director, or otherwise the manager or the secretary or the officer in charge of receiving summons. This is supposed to be given via registered post, RPID जिसको बोलते हैं, registered post acknowledgement due. And if it is a partnership firm, one of the partners of the firm can receive the summons in the partnership firm's stead. And usually all of this is hunky-dory until such time as the person who is supposed to be receiving the summons is not found, cannot be found, or is refusing to take summons. All of these things are practical aspects that are discussed in the procedural law, BNSS. They have got provisions that deal with when there is a situation where a person that is supposed to be served summons cannot be found. Now, a serving officer, like the police officer who gets to serve the summons, he can only come to the conclusion that the person cannot be found after exercising due diligence, and it has to be made very clear to the honorable court, and the honorable court has to be convinced of the fact that the investigating officer or whoever is in charge of serving the summons has done his due diligence and has come to the conclusion that the person who is being summoned is not existing at the place that he is supposed to exist, and he cannot be found. And one of the duplicates is supposed to be given or is supposed to be served to an adult member of the family, at which the person who is supposed to receive the summons habitually resides. So at his residence, any adult member, as in any member who is above 18 years of age and who is of sound mind, all of the conditions that are listed in various laws, usually in the contract law, these things are listed. Any adult member of the family residing habitually at the place where that person who is supposed to be receiving the summons resides is supposed to be served one of the duplicates of the summons, and the receipt is supposed to be taken, as I was mentioning previously. The receipt is supposed to be taken at the back of the duplicate, and it is mentioned in the section specifically that anybody who is gainfully employed by that family, say a chartered accountant or a cook or a driver or anybody who is employed by that family cannot be considered as a member of the family. Therefore, if the serving officer goes to the residence, and if there is a person who claims to be employed by the person who is supposed to be receiving the summons are not supposed to be served on that person, because that person by law, by this act at least, cannot be considered as one of the members of the family. Now, if there is no member of the family that habitually resides in the residence given, then the serving officer shall affix one of the duplicates of the summon to some conspicuous part of the house where that person resides. It may be the gate, it may be somewhere that is prominently visible where the summons is supposed to be affixed, and upon inquiry by the court, this fact is supposed to be disclosed to the court, and the court might either consider the summons as served, or the court may order the fresh service of summons. Two things will happen after the serving officer has done his due diligence and has come to the conclusion that the person on whom the summons is supposed to be served is not to be found. He either is supposed to go to the residence and serve the summons upon any adult member of the family who is not an employee of the family, who belongs to the family, is supposed to be served the summons. If there is no such person available, then the officer shall affix the summons to a conspicuous part of the house or the homestead, meaning the vicinity of the house, where it is supposed to be seen by the naked eye in a conspicuous place. And upon inquiry by the court, this fact has to be disclosed, that the some serving officer was not able to get in touch with anybody who is a member of the family, and he was not able to get in touch with the person on whom the summons is supposed to be served. And then the court might do two things. Number one, the court might consider the summons as served, or the court might order the serving of a fresh summons. Now, if the person who is supposed to be served the summons is a government officer, what should be done? Now, the government officer should be in active duty for this section to be applicable. He should not be a retiree. He should be a government officer who is in active duty, and the summons is not supposed to be served upon the government officer directly. The head of the department the head of the department is supposed to be approached, and the duplicate of the summons is supposed to be served on the head of the department, and the head of the department by law is obligated to cause the summons to be served upon the person on whom the summons is supposed to be served, and then endorse the duplicate and return the duplicate. The endorsement is supposed to be done under his seal, and his signature has to be present, and along with the signature of the person on whom the summons is supposed to be served. All of this is supposed to be returned to the court, and all of that is supposed to be duly endorsed by the head of the department. Now, all of this happens within the jurisdiction of the court serving the summons. Now, if a person on whom the summons is supposed to be served is outside of the jurisdictional limit of the Honorable Court, that he is the originator of the summons, then what is supposed to be done? Well, a duplicate is supposed to be sent to the magistrate, under whose jurisdiction the person who is supposed to be served the summons exists at that point of time, to the magistrate or the district superintendent of police or to the commissioner of police. A duplicate of the summons is supposed to be served, and then out of these three, anyone or all of them can further the process and employ a serving officer within that jurisdiction to complete the service of summons. This is one thing that happens. The other thing that happens is that the originator, the court, the honorable court that is serving the summons already has appointed a serving officer within its own jurisdiction, and the serving officer has gotten to know that the person on whom the summons is supposed to be served has gone outside of the jurisdictional limit of the originating court, and then he goes into the jurisdictional limit of where that person is said to exist, and then he gets the duplicate endorsed by the SHO, anybody who is in charge of a police station, or the magistrate. And after the said endorsement is given by either the SHO or the magistrate, it is as if the summons has originated in that particular jurisdictional limit, and the serving officer can have the summons be served on the person on whom the summons is supposed to be served. Now, after the summons is served, the serving officer is supposed to come to court and convince the court that these summons have indeed been served. On the off chance or in the event that the serving officer is not present, what is supposed to be done? Now, there are certain conditions that have to be met in this scenario. The serving officer is somebody outside of the jurisdiction of the issuing court. That's condition number 1. Condition number 2, the officer who has served the summons is not present at the hearing of the case. When the hearing is commencing, the officer is not present. In that case, an affidavit filed before the magistrate that such and such summons have been served shall be admissible as evidence. And when I say the affidavit is supposed to be attached to the duplicate as in the receipt of summons, the endorsement, the above mentioned endorsements by the government officers, the endorsement by the person who has received the summons, all of that is supposed to be attached to the affidavit, and that affidavit is supposed to be filed in the court, and if such affidavit is filed along with all of the endorsement, it is admissible as evidence. Now, all of this is for the accused. What if a witness? Now, usually the process does not change much with respect to summoning a witness. Simultaneously, the witness can be summoned via electronic means and can also be summoned via registered post acknowledgement due, and the summons can go to his habitual place of residence, or to his habitual place of business, or to his office, meaning at a place where the witness is working for gain, as in for a salary. Now, what if somebody refuses? What if somebody refuses to take the summons? There is a very real possibility that the summons might get refused. In that case, give me 1 second. Am I audible?
Yes.
Right. If right. I'll continue now. The postal employee serving the summons may endorse or acknowledge that the witness has refused to take delivery of the summons. Usually, when summoning a witness, the postal officer is in charge of serving the summons. The endorsement, if the postal employee that is doing the serving acknowledges that the witness has refused to take delivery of the summons, then the endorsement of the postal employee is deemed to have been duly served. The summons is deemed to have been duly served. Now let us come to warrants. All of that comes under summons. Summons are usually served. Summons are usually associated with offences that are not that grave in nature. Now coming to warrants. a warrant is issued by a higher authority to a lower authority. In this case, the Honorable Court issues a warrant to the investigative agency. Right. So, how is a warrant? There is also a process for the warrant to be issued. The warrant is supposed to be issued in writing and is supposed to be signed by the presiding officer of the court, and it is supposed to have the seal and endorsement of the court. It is supposed to be under the court seal, the originator court, and the warrant is supposed to be in writing, and it is supposed to be signed by the presiding officer of the court. Now, what is the time limit of the duration during which the warrant shall remain in force? A warrant shall remain in force until either it is cancelled by the court that has issued it, number one, or it has been executed. They have caught the person, they have taken the person in remand. Only then the warrant shall cease to exist. The warrant shall remain in force until it is cancelled by the court that has issued it, or until after it has been executed. Now the court that has issued a warrant has got the power to ask for security. As we were discussing in the last session, the security is nothing but bail. Bail is nothing but security, and the court that has issued a warrant has got the power to ask for a security. It may direct the endorsement on the warrant. There is a bail bond that is supposed to be executed. There is some money that is supposed to be in escrow, and the officer on whom the warrant is directed shall take such security and release such person from custody. This is the power of the court that has issued the warrant, and usually the security that is supposed to be taken by the officer on whom such warrant is issued derives that power from the court that has issued the warrant. And the endorsement that the warrant is supposed to contain is, number one, the details that are supposed to be written down are, number of sureties, as in the number of people that are required for the bail amount. Number of sureties, the amount, as in 10,000, 20,000, depending upon the Honorable Court's discretion. The amount that is bound to be paid as security for the person who is going to be bailed out, and the time and the date at which the person to whom the security is paid, the person who is receiving the bail, the time and date at which he is supposed to be presented in front of the Honorable Court, and this endorsement is supposed to be forwarded to the court by the officer on whom the warrant is issued. Now, usually the warrant is issued by the court to the police officer, usually to the police, but then there are certain exceptions to this rule. Ordinarily, to one or more police officers the warrants are supposed to be issued, but if immediate execution is necessary and in certain situations where there is no availability of police officers, in those situations either any other government servant or any other person can be issued a warrant. Now there is something called a proclamation, where a person who is evading arrest on whom a warrant is issued is proclaimed an offender. Now, when I say a warrant can also be issued to any other person apart from a police officer, that person is not just any other person. Whenever the court is privy to the information that the proclaimed offender is located within the property under a person's control, that is a person on whom the warrant can be directed to take into remand the proclaimed offender and then hand him over to the police. Now, all of these people can be issued warrants, and it is not like only one person who has made his move first is supposed to be executing the warrant. All of them, or any one of them, and more than one of them, all of them can execute the warrant. All or any one or more than one. This has been written in the section, therefore I am saying it with such gusto. All of them or any one of them or more than one of them can execute the warrant. Now, upon the receipt of the warrant, either the police officer or anybody else, upon receipt of the warrant, an acknowledgement is supposed to be given in writing, and upon execution there is another acknowledgement that is supposed to be given. Now, upon the arrest of the person on whom the warrant has been issued, he shall be made over to the nearest police officer. If on the off chance a police officer is not doing the arresting, the person that has been arrested shall be made over along with the warrant to the nearest police officer, who in turn is supposed to be taking that person over to the magistrate having adequate jurisdiction. All of this is supposed to happen when there is no security taken. If the security has been taken, the arrest happens, and then right after that the person who has been arrested may be enlarged on bail. The security is supposed to be given by the honorable court that has issued the warrant, that the securities, the amount of money that is supposed to be taken as security, the number of sureties, all of these things is supposed to be given by the honorable court that has issued the warrant. Now, oftentimes what happens is that a police officer that has been issued a warrant might not be in a position to be able to execute said warrant, and by law it is allowed for a police officer to forward that warrant to be executed by another police officer via an endorsement. So if police officer A is issued a warrant to arrest so and so person, and if that police officer is unavailable or due to any extraneous reason that police officer is not able to execute the warrant, he may via endorsement have another police officer B try and execute that warrant via endorsement. That option is given by law to the police officer on whom the warrant is issued. Now, after the police officer arrests the person, takes that person into remand, the substance of the warrant should be explained in terms that are understandable to the person that has been taken into remand. Number one, the warrant is supposed to be shown to the person that is that has been taken into remand. Number two, and the substance of the warrant shall be explained to the police officer, explained by the police officer to the person. In the event of the person not being able to understand the substance of the warrant after it has been shown to him, showing the warrant and making the person understand the substance of the warrant that has been issued against him is the responsibility of the police officer making the arrest. Now, after the execution of the warrant, meaning after the arrest has happened, there is a certain time period that is given to the police officer to bring the person on whom the warrant is issued to the court, which is usually 24 hours notwithstanding the time taken to travel. Say if the police officer goes from Maharashtra to Gujarat to apprehend somebody, and if he is successful in executing the warrant, the time period that is allotted for said police officer to bring back the person on whom the warrant is issued is 24 hours, notwithstanding the time taken for that police officer to travel to and fro from Maharashtra to Gujarat and from Gujarat to Maharashtra. The time taken is excluded, and 24 hours is the time period, the time limit that is given to the police officer that has gone to make the arrest or to execute the warrant. Now, where can a warrant be executed is one other question. Once a warrant has been issued by a court of competent jurisdiction, that warrant may be executed anywhere within the territory of India. Now, that can be a territory that is within 12 nautical miles from the territory of India. That can be on an international vessel that is flying under Indian colors, meaning bearing the Indian flag. That can be anywhere. Technically, there is certain conditions, there is certain definitions as to what kind of territory comes under the territory of India, and within all of those categories and in the taking the complete meaning of the definition, within the territory of India, a warrant may be executed anywhere within the territory of India. Now coming to proclamation. Say a person on whom a warrant is issued has evaded the execution of the warrant against him successfully. He has evaded arrest and he has evaded everything else. Then that person is proclaimed as an offender. It is the honorable court that has issued a warrant. He has the power to proclaim the person as a proclaimed offender if that person has successfully evaded arrest, successfully evaded the execution of the warrant. Now there is a specific process for this as well. To issue the proclamation, there is a specific process that is supposed to be followed by the honorable court, and the proclamation contains the following. The proclamation that is issued contains certain directives to the person who has evaded the arrest. The directives are that the person should be present at a specific place at a specific time within the elapse of 30 days from the date of the issuance of the proclamation. A specific place and a specific time is mentioned in the proclamation, and said proclamation is attached or affixed to a prominent place in the court, to a prominent place in the habitual residence of the person who has been issued the proclamation, on whom the proclamation has been issued, and 30 days is usually given. 30 days is usually given for the person on whom the proclamation is issued to comply with that proclamation. Now, how is that proclamation published? As I was saying, a conspicuous place where the person habitually resides, a conspicuous part of the residence or homestead, homestead meaning the residence and all of the occupying area. Now it is supposed to be conspicuously affixed to a copy. All of these copies are supposed to be affixed to conspicuous places where the proclaimed offender might be located. A copy is also supposed to be affixed to a conspicuous part of the courthouse, and if deemed necessary by the honorable court issuing the proclamation, if deemed necessary, the proclamation might get published in a daily newspaper that gets circulated where the person habitually resides. So a conspicuous place where he habitually resides, number one, and a conspicuous part of the home or homestead, number two, a conspicuous part of the courthouse, number three, and if the honorable court that has issued the proclamation deems it necessary, published in a daily newspaper that gets circulated where the person against whom a proclamation is issued habitually resides. Now, as proof, one was vernacular and other was English, yes. I will have to get back to you on that, but as far as my knowledge goes, there is no change in that. But I will, yes, two newspapers, one in English and one in the vernacular, the language that is usually used by the person against the proclamation, against whom the proclamation is issued. But I will get back to you, Mr. Murarilal, with more detail on this. I will try and find out for myself whether or not there has been any change in the new law. Now, as proof of proclamation, yes, as proof of proclamation, a statement officially made by the court mentioning the time and day of the issuance of the proclamation is proof enough that a proclamation has been issued. Usually when a proclamation is issued, there is supposed to be a proof that is supposed to be filed in the file, right? When there is court proceedings, there is a lot of proofs that is supposed to be in trial. There is a file, and in that file there is supposed to be filed a proof of proclamation. A proof of proclamation is a statement that is officially made by the court mentioning the time and the day of the issuance of the proclamation. When or after a proclamation is issued, if the court gets to know that the proclaimed offender is trying to sell off one of his properties, or is trying to, it can be either movable or immovable, is either trying to sell off one of his properties or trying to remove one of his properties from the jurisdictional limit of the honorable court issuing such proclamation, then according to the discretion of the honorable court issuing such proclamation, the honorable court may also issue an attachment order, meaning a person evading the arrest on whose name the property exists may be attached, meaning with the proclamation an attachment order is issued, thereby preventing that person on whom the proclamation is made from disposing of his property, whether it be movable or immovable. But it is supposed to happen via the discretion of the honorable court, and after credible information is given to the honorable court that a person against whom a proclamation has been issued is trying to alienate his property, or alienate his immovable property, or is trying to remove his movable property from the jurisdictional limitation of the honorable court that has issued the proclamation. Now, how do we satisfy the court that this is happening? The court has to be satisfied by an affidavit or otherwise. And via due process, this the honorable court that has issued the proclamation is supposed to be satisfied, and only after such court is satisfied can the attachment order be issued along with the proclamation. Now I will do a quick recap, and also I would like to mention that in the schedule of BNSS there is a format that is supposed to be followed whilst issuing summons and warrants. The formats are already existing in the schedule of the BNSS. Now, summons and warrants, they are processes to compel the appearance of an accused or a witness or things or objects. Now, summons are usually associated with offences that are not that grave and not that serious. Summons can be served to accused, to witnesses, be it prosecution witnesses or defense witnesses or court witnesses. Summons are usually served to the person who is getting summoned. Warrants are usually issued by a higher authority to a lower authority, the higher authority being the honorable court and the lower authority being the investigating authority, the police. And the form of summons are supposed to be thusly given in writing and in duplicate. The duplicate is supposed to be signed or endorsed by the person who is receiving the summons, and these summons are supposed to be given in writing and they are supposed to be signed by the presiding officer of the court, and they are supposed to be bearing the seal of the court, and the summons are usually served by a police officer or an officer uh, of the court that is issuing it, or any other public servant. And the summons are preferably served personally. The duplicate doubles up as a receipt, and the duplicate is supposed to be signed by the person receiving the summons. And the summons are usually served to people or corporate persons. Corporate persons are companies which have legal a company is usually in legal parlance referred to as its own person, as a separate legal entity which has got liabilities and responsibilities. Therefore, for a summons to get served on the name of a company, it is usually delivered to whoever is by consensus in charge of receiving such summons. It might be the director, the manager, the secretary, or officer in charge of receiving the summons. It might be served via registered post or via electronic means. If the person on whom the summons is supposed to be served cannot be found, after exercising due diligence, the officer that is in charge of serving the summons can serve a duplicate on one of the adult members of the family of the person on whom the summons is supposed to be served. An adult member of the family habitually residing at the residence of the person on whom the summons is supposed to be served. The receipt is taken on the duplicate. Anybody who is employed by the family does not come under consideration as one of the members of the family. Now, in case there is no such person, no kith and kin habitually residing at the place of residence, the serving officer is supposed to affix one of the duplicates of the summons to some conspicuous part of the house where that person habitually resides, and upon the inquiry of the court, all of this information is supposed to be revealed to the court, and the court might either say that the summon has been served or order fresh service of summons. And the summon is supposed to be served on a government servant who is in active service. A government servant is not supposed to receive the summons directly. The HOD is supposed to receive the summons instead, and the HOD in turn is supposed to cause the summons to be served to whoever it is that is supposed to be receiving it, and the HOD is supposed to return the duplicate to the court bearing his own endorsement and the endorsement of the person who is being summoned. Now, if the summons is said to be served outside of the local limit, two things can happen. Thing number one is that the honorable court issuing or serving the summons serves the duplicate to the magistrate having jurisdiction, or to the district superintendent of police serving in that jurisdiction, or to the commissioner of police serving in that jurisdiction. The second thing that can happen is that the serving officer who has already been appointed as the serving officer of the summons gets in touch with the SHO within that jurisdiction, within the jurisdiction in which the summons is supposed to be served, and gets that summons endorsed by either the SHO or the magistrate who has got adequate jurisdiction, and he can take it from there. Now, service of summons to the witnesses, usually police officers do it, but the postal officers might also do it. It can happen simultaneously via electronic form or registered post acknowledgement due. All of these things can be simultaneously sent to either the residence of the witness or a place of habitual business of the witness, or where the witness is working for gain, as in salary. Now coming to warrants. A warrant is also supposed to be issued in writing, signed by the presiding officer of the Honorable Court and bearing the seal of the Honorable Court issuing the warrant. The warrant shall remain in force until either it is cancelled by the Honorable Court that has issued such warrant, or until such time it is executed. Until such time, the warrant shall continue to remain in force. Now, any court that has issued a warrant has got the power to ask for security, which means bail, and that court that has issued the warrant may direct an endorsement on such warrant. The officer to whom the warrant is directed shall take such security and release such person from custody. The endorsement that is supposed to be given by the officer in charge of executing the warrant shall contain these following details: the number of sureties, the amount that the sureties are bound to pay, the time and place at which the person on whom the warrant is issued is supposed to be presented in front of the court, and such endorsement is supposed to be forwarded to the court by the serving officer, meaning the officer in charge of executing the warrant. Usually the warrants are directed towards the police officers, one or more of the police officers, but if immediate execution is necessary, other government servants may also be issued warrants, and other persons may also be issued warrants in the off chance that a proclaimed offender is found, or if the court receives credible information that a proclaimed offender is located in a property on which proclaimed offender is said to be located in a property that belongs to any person, that person may also be issued a warrant, and if such person can execute the warrant, that person is supposed to forward or hand over or make over the person to the police, and such person and or such police officer shall in turn take that person and hand him over to the magistrate having adequate jurisdiction. Right, and if a police officer on whom a warrant has been issued finds himself in a position to not able to execute the warrant, he can via endorsement have another police officer try and execute that warrant in his stead. And after grabbing hold of the person, after the person on whom the warrant is issued has been detained, that person is supposed to be read out the substance of the warrant. He has to be shown the warrant, and in a language that is understandable by that person who has been detained, that warrant is supposed to be explained, and the substance of the warrant is supposed to be explained, and it has to be shown to that person. The time period that is given to the police officer or whoever executing the warrant, the time period that is given after the execution of the warrant to present that person in front of the honorable court or to the magistrate is 24 hours, notwithstanding the time taken to travel to and fro from the place of origin to the place where the person has been found and back. 24 hours notwithstanding, as in minus the time taken to travel to and fro. And a warrant can be executed anywhere within the territory of the country. Within the territory of India, a warrant can be executed anywhere. Now, if a person has successfully evaded arrest, a proclamation can be issued by the court issuing the warrant. Now, a proclamation will contain the time and date at which the person is supposed to be at a particular place. A place is specified, a specific time is specified, and at that time, at that place, the person is supposed to present himself. And after the proclamation has been issued, a time period of 30 days is given to the person to present himself at that particular place. Now, a proclamation can be affixed to any conspicuous location in the residence of the person, the habitual residence, or any particular conspicuous place in the courthouse, and if deemed necessary by the honorable court that is issuing the proclamation, a newspaper that gets circulated where the person habitually resides. Now, the proof of proclamation is a statement that is officially made by the honorable court mentioning the time and day of the issuance of the proclamation is supposed to be affixed to the file. Now, this has been a brief about summons and warrants and attachment and proclamation. Attachment happens when the honorable court receives credible information that a proclaimed offender is trying to either alienate his immovable or movable property, or trying to remove said property from the jurisdictional limitation of the honorable court. Then, along with the proclamation, the properties of that person may be attached. This has been Summons and Warrants, Chapter 6 of BNSS, the law that has replaced the CRPC. Now, I shall try and forward the PPT and other reading material by the end of tomorrow, and I shall also try and notify this group about the topic that is supposed to be covered tomorrow. If there is anything that the participants might like to add, or if there is any questions, I will try and find out the answer to those questions, and I will try and answer those questions. Otherwise, this is the end of the session. Yes, that is a scam. Yeah, that's the scam. That's pretty famous. That will be famous. Yes. Right, I'll tell you, Mr. Ashish, you are not the only one that is fascinated by all of this that is happening. First time I have heard of such a thing happening, even I was fascinated. A lot of people who are educated, a lot of people who are supposed to be privy to such information, all of this information are the ones that are getting used. but there is a process to the arrest. When punch witness is supposed to be present, they can also be summoned by the police. Summons can also be issued by the police. But all of this should happen via proper channel and through proper procedure. And if that procedure is not followed, the arrest itself is rendered invalid. But yeah, a lot of people are getting it because they are not privy to this information. There is basic information that a lot of people are not privy to, even if they are bureaucrats. Yes. 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 Fraudulent cake. Yes. So many cases have happened. Yes. Yes. Advocates, some advocates have been due. Yes. Lack of awareness. You're right. You're right. Right. Nowadays, artificial intelligence is also being used. The scamster doesn't even have to use his own intelligence. Even that part is being taken care of by scientists. It is already telling us. It is already telling us. Usually citations. I have seen some of my colleagues use AI to find out citations. And more often than not, those citations are wrong, but on the off chance that the citations are right, we are looking at artificial intelligence telling us how to and what to present in front of the honorable court while making the submissions. Yes, 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 there are. No, yes, that is true, and one should also only rely on AI after gaining the capacity to do it on one's own. If I do not know whether or not the citation that has been given to me by the artificial intelligence is correct, I cannot present it in front of the honorable court just like that. I will have to have the capacity to find out whether or not that is correct. Right, sir, right, everybody, thank you very much. I shall try and make the PPT available for the participants at the end of this day or by tomorrow, and I shall also forward the title of the next session by tomorrow to the participants. Thank you.
यहाँ से लगा
జల్లు డిస్ట్రాక్ట్ అయిపోయిన కనుక ఏమేమో అవుతుంది అది
పర్లేదు